The morning they filed the papers, I was in my garden, pulling up dead tomato vines. That's the image I keep coming back to. My son coming around the side of the house with that look on his face. Not the look of someone delivering bad news, but the look of someone who'd already decided I wouldn't understand it. He was 41 years old, and he was looking at me the way you look at a dog you're about to put down. Dad, we need to talk about some things. I had dirt on my hands. I remember that specifically. I didn't wipe them off. I just stood there and let him talk. He said the family was worried. He said my daughter-in-law had noticed some things. He said it wasn't about money. And that's always the sentence that means it's about money. He talked for maybe 4 minutes. When he finished, I nodded once, told him dinner would be ready at 6, and went back to my tomatoes. I didn't say anything else because I had learned, a long time ago, that silence is the sharpest tool in the box. And I had spent 40 years in a profession that required me to use it precisely. My name is Bernard. I'm 67 years old. I was a structural engineer for 38 years. Bridges mostly. Highway overpasses. A few stadium foundations on the East Coast. I'm not famous. Nobody writes about structural engineers unless something falls down. But I was good at what I did, and the reason I was good at it was the same reason my son underestimated me that afternoon. I don't react. I assess. My wife, Lorraine, she died 4 years ago. Pancreatic cancer, 8 months from diagnosis to the end. She used to say I was the only man she ever met who could receive terrible news with the exact same expression as a grocery list. She didn't mean it as a compliment, but after 35 years of marriage, she understood that underneath the stillness, I was always working. She left me a good life. We left each other a good life. We'd been careful with money, paid off the house in Vermont by the time we were in our 50s, and I had a pension from the firm and a modest investment portfolio I'd built slowly over 30 years. Nothing extravagant, but comfortable. More than comfortable. After Lorraine died, I moved slower. I sold the house in Vermont, too big, too many rooms that had been hers, and bought a smaller place in western Massachusetts, a farmhouse with 4 acres and a view of the hills that she would have loved. I meant it as a tribute to her. I still think of it that way. My son moved back from Seattle about 8 months after the funeral. I thought it was grief. I thought he wanted to be closer to family. He brought his wife with him. A woman I'd only met 3 times before, a real estate agent with a warm smile and very fast eyes, and they rented a house about 20 minutes from mine. I was glad to have him near. That's the honest truth. I missed Lorraine every single day, and my son is all the immediate family I have left. I welcomed him. I let them come for dinner twice a week. I let his wife ask questions about the house, about the property taxes, about what I planned to do with all that land. I should have listened more carefully to the questions she was asking. The first concrete thing I noticed was in February. About 5 months after they moved back, I was reviewing my brokerage statements and found a transaction I didn't recognize. Not a fraudulent one. Nothing that dramatic. It was an advisory fee. $320 charged by an investment management firm I had never heard of. I called the brokerage. After 45 minutes on hold, a representative told me that a limited power of attorney had been submitted on my behalf approximately 6 weeks prior, authorizing a wealth management firm called Halcyon Partners Group to assess and advise on my portfolio. I asked her to repeat that. She did. I asked who had submitted the authorization. She said she couldn't tell me over the phone and suggested I come into the branch office. I went in the next morning. I brought my own copy of the power of attorney I had drawn up years ago, the one naming my son as my agent in case of incapacitation, narrowly defined, with Lorraine as primary and my attorney as secondary. That document was specific. It was not a blank check. What had been submitted to the brokerage was a different document, a broader instrument that I did not remember signing, using language I had never approved and bearing a signature that did look, vaguely and unsettlingly, like mine. I sat with that for a week. I didn't call my son. I didn't call my daughter-in-law. I called my attorney instead, a man named Jeffrey, who has been my lawyer for 22 years and who, if you put him in a room with a problem, tends to stay there until the problem is solved. Jeffrey looked at both documents and said 4 words. This is a forgery. Not suspected. Not possible. A forgery. We spent the next 3 weeks working quietly. Jeffrey hired a forensic documents examiner. The examiner compared the signature on the Halcyon authorization to 8 confirmed exemplars of my handwriting over the past decade. His conclusion was unambiguous. The signature had been traced or digitally manipulated from an authentic document, most likely the original power of attorney itself, which my son had a copy of. I still didn't confront anyone. Here is the thing people don't understand about structural engineering. The most important work happens before anything is visible. You don't start laying foundation until you've accounted for every variable. Soil composition, load distribution, stress points. What happens in a 100-year storm? If you rush to build before you understand what you're building on, everything falls eventually. I applied the same discipline to this. Jeffrey filed a quiet report with the State Financial Regulatory Authority and the Attorney General's office. We put a legal freeze on any further transactions under the fraudulent authorization. We pulled every record we could on Halcyon Partners Group. What we found was not surprising, but it was thorough. The firm had one real client, my son's household. They had been routing advisory fees through my account and into an operating account that my daughter-in-law had administrative access to. Over 6 months, the total extracted was just under $14,000. That was the documented portion. What we couldn't prove yet was how much more they had planned. But based on the paperwork we found, and Jeffrey had become very good at finding paperwork, they had begun the process of petitioning for a formal guardianship determination. The argument they intended to make was that I was showing signs of cognitive decline. My son was going to tell a court that his father couldn't manage his own affairs, the same father who had, without his knowledge, already filed a 40-page evidentiary record with the state attorney general. I want to be honest with you about what that felt like. I've tried to tell this story without self-pity because self-pity is not useful, and Lorraine had no patience for it. But there were nights. 3 or 4 nights in particular, where I sat in the kitchen at 2 in the morning and felt something I can only describe as a cold collapse behind my sternum. Not anger, not even grief exactly, something closer to the specific loneliness of being misunderstood by someone you raised. I thought about his childhood. I thought about the years I worked late so he could go to the school he wanted. I thought about the summer Lorraine was sick and he flew back twice, how I thought that meant something about who he was. I thought about how much she loved him and how she would have wanted me to find a way through this that didn't destroy everything. I thought about all of it, and then I went back to work. The guardianship petition was filed on a Thursday in April. I was informed by Jeffrey that afternoon. The petition alleged, among other things, that I had become increasingly confused about financial matters, that I had made erratic and impulsive decisions regarding my property, and that I had, on at least 2 occasions, failed to recognize family members during visits. That last one was my favorite. I have never in my life failed to recognize anyone. The hearing was scheduled for 8 weeks out. My son and my daughter-in-law clearly expected me to receive the petition as a devastation. Maybe they expected me to call my son, emotional and frightened, and ask what was going on. Maybe they expected to show up at my door with explanations and reassurances and documents for me to sign. Instead, I called to tell them I'd seen the petition and ask if they wanted to come for dinner Sunday. My son said yes. Sunday dinner was quiet. My daughter-in-law watched me the entire meal with the expression of someone conducting an evaluation. My son talked about weather and the garden. Nobody mentioned the petition. I made pot roast, which was Lorraine's recipe, and I cut the carrots the way she taught me, in long diagonal pieces, so they hold their shape. When they were leaving, my daughter-in-law hugged me at the door. I felt her take in the house. The art on the walls, the furniture, the way the late light came through the back windows across the fields. "You've kept the place so well," she said. "It's a good house," I said. "Worth keeping." She smiled. I smiled. After they left, I sat down and made notes on everything that had been said during the meal. Jeffrey and I had agreed that I would document all contact with my son and daughter-in-law from that point forward. I logged time, duration, topic, any statements relevant to the petition. The hearing was on a Wednesday morning. I remember driving to the courthouse in clear weather, the hills still green, a town I'd come to know over 4 years of living nearby. I wore my good charcoal suit, the one I bought for Lorraine's memorial service, and I carried a briefcase that Jeffrey had packed the evening before. My son and my daughter-in-law were already inside when I walked in. They were seated at the petitioner's table with their attorney, a younger man in a light gray suit who held a yellow legal pad. My daughter-in-law saw me first. She leaned toward my son and said something, and he looked up. He didn't laugh. I want to get that right. He didn't quite laugh. It was more of a release of breath, almost amused, like he'd expected me to show up confused or defeated or with the wrong paperwork. When he saw me walk in steady and suited and carrying a briefcase, something in his face recalibrated. Not worry exactly, something closer to mild inconvenience. His wife touched his arm. She was already composed. She had the manner of someone who had practiced this. Their attorney stood to address the judge as the session opened. The judge was a woman in her early 60s, sharp-faced with reading glasses on a chain. She reviewed the opening documents without expression. Then Jeffrey stood up. He said my name, Bernard Calloway, and my occupation. Retired structural engineer, and then he said something else. A title. A second identity that I had carried for almost 15 years and never mentioned to my son. A work I had done quietly alongside my engineering career that had eventually outgrown the engineering. I had written 6 books. 3 of them were financial literacy guides for working families. Written under a pen name, published by a small press, not particularly famous, but steady sellers for a decade. The other 3 were more technical, estate planning frameworks for clients of mid-sized investment firms. The last one had been adopted as reference material by 2 state bar associations. I was also, as of 8 years ago, a licensed fiduciary and a certified financial planner. I had spent the back half of my career not just building bridges, but helping people understand what they were building toward financially, quietly, without making it anyone's business. Jeffrey laid the credentials on the table. He then laid the forensic document analysis. He then laid the 6 months of transaction records from Halcyon Partners Group. He then laid the communications, text messages, and emails obtained legally, in which my son and my daughter-in-law had discussed the guardianship filing in terms that were explicit about their intent. There was one message in particular. My daughter-in-law had written, "Once the guardianship goes through, we can move the accounts under the trust structure. The house transfers automatically. He won't be able to contest it." My son had replied with the thumbs-up emoji. The judge looked at those for a long time. The young attorney in the gray suit asked for a recess. The judge denied it. What followed was not dramatic, not in the way you might imagine from the outside. Nobody raised their voice. The judge spoke carefully and precisely. She dismissed the guardianship petition with prejudice, meaning it cannot be refiled. She referred the financial fraud matter, the forged power of attorney and the unauthorized transactions, to the district attorney's office for review. She noted in the record that the respondent, meaning me, had demonstrated exceptional clarity and competence in preparing his own defense, and suggested that perhaps a more thorough evaluation of who required oversight was in order. I looked at my son once during the hearing. Just once. He was staring at the table. He had the look of someone trying to make himself smaller. I didn't feel triumph. I want to be clear about that. I've thought about this a lot in the months since, and what I felt was not victory. It was more like the feeling after a long diagnosis. The relief of knowing what the problem actually is, even when the problem is serious. My son called me from the parking lot. I didn't answer. He left a voicemail that evening. I listened to it once. He said he was sorry. He said his wife had pushed him into it. He said he'd been in a difficult financial position, and he'd told himself it would all work out, that I had more than enough and wouldn't notice, and eventually he'd find a way to pay it back. He cried a little on the recording. I listened to the whole thing, then I saved it. Jeffrey asked me to, and I didn't call back. The district attorney's office opened an investigation in June. My daughter-in-law retained separate counsel. The fraud charge for the forged authorization is a felony in this state, and the pattern of unauthorized transactions over 6 months is a compounding factor. I don't know yet what the outcome will be. That's not mine to control. I provided what I was asked to provide, and Jeffrey handles the rest. What I do know is this. I changed my will. Not punitively. I didn't sit down and redesign it in anger. But the original will had been written when my son was 26, and I assumed certain things about him that turned out not to be accurate. The new will creates a charitable remainder trust in Lorraine's name, directed toward a hospice organization she cared about. It makes a modest provision for my son, contingent on circumstances I won't describe here. The rest goes where she and I agreed it should go, years ago, in conversations we had late at night when we still had time. I finished the farmhouse garden this fall. Got the tomatoes right this year, planted them earlier, staked them better, kept the soil amended through July. I eat dinner alone most nights, and I've made my peace with that. My neighbor across the road, a retired school teacher who moved up from Connecticut 2 summers ago, comes by on Sundays, and we play cards and argue about things we both find interesting. It's a good arrangement. I think about Lorraine. I think about what she would say about all of this. She was not a sentimental woman when it came to betrayal. She came from a family where loyalties were tested early, and she had no patience for people who chose convenience over character. But she also believed that the purpose of understanding what a thing is made of is not to condemn it, but to know where it will hold and where it will break. My son is made of materials I apparently didn't test carefully enough. That is partly my failure too. I was not always present. I worked long hours for a long time, and I told myself that providing well was the same as being there, and I was wrong about that in ways I still don't fully understand. I don't say that to excuse what he did. I say it because it's true, and because accuracy matters more to me than a clean story. What I know for certain is this. I walked into that courtroom under my own power, with my own documentation and everything they had built their case on. The assumption that I was declining, that I was manageable, that I could be arranged like furniture, collapsed the moment I set a briefcase on the respondent's table. I spent 40 years building things that had to hold weight. Bridges don't stay up because of hope or good intentions. They stay up because someone did the math. I did the math.